How to get a high grade in your equity and trust exam or assignment. First of all, before we dive into equity and trust revision, I'd like to introduce myself. My name is Nini. I'm founder of Simple Studying. I have LLB and LLM degrees from City University of London. I've got very high grades when I was at law school, and then I built Simple Studying to help other law students also successfully graduate with good grades. We are building AI-powered higher education and career building tool. So we started with providing educational support services to law students. That was our first product. But now we are expanding to other higher education areas as well and helping students not only with getting high grades, but also finding internships and jobs. Why you should trust us. We have over 25,000 registered customers already in the UK. That's like 25% of total law students in the country. 90% of our regular customers who got premium subscription and at least 6 hours of tutoring have reported to have got a first class. So our system definitely works. It is a tested method. We have worked with thousands of law students in the UK, and we know exactly how to get a first class, as it is evidenced by our reviews. Here are the key topics that we should revise today about equity and trusts. 3 certainties, non-charitable trust, fiduciary duties, and gifts. These are the topics that usually come up in equity and trust assignment or exam, but I strongly recommend you to review the lectures in your course, in your specific university, to make sure that there are no other topics that you should be revising, but these are usually the key ones, but there could be other ones as well. The only way to know it is to look at your lectures. Use the IRAC structure. Most of the students know about IRAC structure, but hardly ever implement it in practice correctly. So I cannot emphasize enough how important this is to follow the IRAC structure with every single thing that you write, not just about equity and trust, but every single study module, whatever exam you have in law. IRAC structure for problem questions is the way to get a first class, but properly implemented one. First, you have to identify what is the legal issue. This is not summary of the facts of the case. This is basically saying something like, and it should be discussed if there is certainty of intention in this case. This is a legal issue. Legal issue is to state what exactly are you going to discuss in terms of law in this paragraph, rather than summarizing the facts of the problem question. Afterwards, after the statement of the legal issue, you need to talk about the law. So if it's certainty of intention, you need to explain what is certainty of intention and cite the relevant cases or statutes. Then application. This is where you discuss the facts of the problem question. Here you need to talk deeply about how the law applies to the problem question given. Do not just simply summarize the problem question. That's not required at all. You're supposed to tell the examiner how the law that you just discussed applies to the problem question and advise the parties in the problem question. And at the end, you have to conclude what is the most likely outcome. In law, you don't have right or wrong answers, or you don't have one specific answer. Usually there are multiple answers. It's not math. So what is the most likely outcome given the circumstances? This is what you need to conclude. You remember, for a first class, you need to correctly identify at least 80% of all the legal issues that arises in the problem question, and following the IRAC structure, provide critical analysis with a very clear constructive arguments. This is how you get a first class. But remember that this is not something you can just learn in a day. This is practice. Like, you need to be practicing answering problem questions over and over again for months or even years to get really good at it. So my suggestion would be to answer as many problem questions as you can from past exam papers before you go to an exam, so you know exactly and you have practiced enough how to answer problem questions on common equity and trust exams. So first of all, what are three certainties? This is like this cornerstone of equity and trust. You cannot pass an equity exam without knowing these three. Certainty of intention, certainty of subject matter, and certainty of object. Make sure you remember these three certainties and know what they are and what are the key cases on each, and what are the principles that these key cases have established. Certainty of intention. Well, certainty of intention is a verbal expression of an intention to create a trust. The said law must have intended to impose a legal obligation on the trustee as opposed to a mere moral obligation. It must be clear that said law intended to create a trust rather than a loan or a gift. So according to what the said law said, that should be what you need to discuss to show the intention that the said law intended to create a trust specifically rather than something else. Like, was it a gift? Was it a loan? Was it a trust? Why? You have to refer to the words of the said law to show why you think this is a trust and not something else. And see the cases of Paul versus Constance and Re Cavett, because just looking at the words of the said law in a problem question, it will be very hard for you to determine if it's a trust. You just need to look at similar cases and according to that, construe your critical analysis. Certainty of subject matter. This is about the property that is subject to the trust. The trust property must be segregated from other properties and identifiable or identified already. If it's not separated, then the court will most likely hold that it's uncertain and the trust will fail. See the case of a re-London wine and Hunter versus Moss. The law makes a distinction between tangible properties and intangible properties, and you will learn more about that in those two cases, Re-London Wine and Hunter versus Moss. You can read the case summaries of these cases at simplesetting.com at our platform. Certainty of objects. Beneficiary principle. Certainty of objects is basically if it's certain who is supposed to benefit from this trust. We have a beneficiary principle in trust law, which basically means that for a trust that is not charitable, for a trust to be effective that is not charitable, the beneficiaries of the trust must be identifiable. The court must know who exactly is a beneficiary. And you should have a look at the test. The test was discussed in Macphail versus Dalton. Again, you can go to simplesetting.com and look up this case and read the case summary. Reading case summaries on our platform is free, so you can do that. A trust can be void if the objects of that trust are uncertain. So we need certainty of intention, certainty of subject matter, and certainty of object for a non-charitable trust. For charitable trusts, you don't need certainty of objects. We'll talk about that later. Non-charitable trust. Express, resulting, and constructive trusts are all trusts for ascertainable individuals. Non-charitable purpose trusts are private trusts that are usually void. So again, this is related to the three certainties principle. If there is no certainty of objects, the trust will be void if it's not charitable. But there are few exceptions, anomalous cases that courts have held to be effective, even though they do not comply with the three certainties rule and they're not charitable. These exceptions are trusts for maintenance and monuments and graves, trusts for maintenance of animals, promotion and furtherance of fox hunting, and trust for religious service. The reason why these trusts are valid, even though they're neither charitable nor comply with the three certainties requirement, is because it's a cultural one, because in the culture, these things are important. So that's why we want to hold them valid. Charitable trusts. The charitable trust is the exception to the three certainties rule. Even if there is no certainty of objects, it's still fine. But we have other requirements here to satisfy. If you have a charitable trust problem question, do not discuss three certainties at all. You can mention that for charitable trust, we don't need a certainty of objects. Can mention that. But this is what you need to mention. Two requirements. First, it must fall within the list of purposes that are set out in Section 3 of the Charities Act 2011. So read what are those, the list of purposes. There are many, like I think it's about 11 purposes that are listed in Section 3. And make sure that you identify the relevant one. So look at the problem question. What is the charitable purpose about? And does it fit under any of the categories recognized under Section 3 of the Charities Act? And second, it must satisfy the public benefit test. The public benefit test, you need to explain what it is according to the case of Oppenheim versus Tobacco Securities. Charitable trust categories include, amongst others, relief of poverty, advancement of education, religion, and other purposes beneficial to the community. So the reason why charitable trusts are recognized, even if they don't satisfy the three certainties rule, is because it's beneficial to the community. And charities do not pay taxes. So that's why it must be beneficial to the community for the tax thing to be justified. Test is whether or not those who were going to benefit from the trust constituted a sufficient section of the community. So the test is about how many people is going to benefit from this charity. If it's like a very, very small group of individuals, the court may say that this is not a valid charity. So it has to be a large enough section of the community to justify the charitable purpose. Yeah, so fiduciary duties is the next one. Next topic that you should revise. Fiduciary is someone who undertakes to act in relation to the property of another. This is the undertaking of responsibility that gives rise to a relationship of trust and confidence. For example, fiduciary relationship can be found between a trustee and a beneficiary, company director and the company, principal and the agent. Here are the legal positions, legal principles that you need to remember about fiduciary duties. In equity and trust exam, they won't cover company director thing, but you will have to know how the fiduciary duties work in terms of trustee beneficiary relationship and what are the rules. You may have a problem question where trustees breached their fiduciary duties, and you need to discuss whether or not this is a breach of fiduciary duties, and what are the effective remedies, what can the beneficiaries do to bring an action against the trustee. Or it can be an essay question as well. I've seen many essay questions about fiduciary duties. It's usually the essay questions that I've seen is about the rule of no conflict rule. The no conflict rule that is coming from the case of Boardman versus Phibbs, and asking whether or not no conflict rule is justifiable, something like that. So these are the duties. No profit should be made out of a fiduciary position. Fiduciary must not place themselves where duty and interest conflict. So this is no conflict rule. Fiduciary must not act for the benefit of a third person without the company's or the beneficiary's permission. There cannot be any conflict of interest. They cannot accept benefits from a third party. And if there is a conflict, it must be disclosed. They may approve it, they may give permission, but if there's a conflict, it must be disclosed. And the leading case is Boardman versus Phelps. Gifts. Absolute and unconditional transfer of both legal and equitable title. That's the difference. So what is the difference between a trust and a gift? In case of a trust, only the legal title is being transferred from the settlor to the trustee, whereas the beneficiary title still remains with the settlor. On the other hand, with the gift, it's an absolute and unconditional transfer of both legal and equitable title to the donee. Ineffective transfer does not constitute a declaration of trust. There are a few formalities that must be followed for a gift to be effective. And if the donor failed to follow these formalities and failed to create an effective gift, the law of trust cannot be used to enforce an ineffective and imperfect gift. That's the rule about equitable, not perfect and imperfect gift that comes from Milroy versus Lord. There are some exceptions around it, but that's the strict rule that is still valid to this day from the case of Milroy versus Lord. Equity cannot be relied upon to perfect an invalid gift. However, if the donor has done everything necessary for her to make the gift, then equity will deem an equitable interest to the relevant property to have passed automatically. That was the case of in Rose. So the donor did all the bureaucratic formalities to make the donation, and he clearly intended to make a gift, but he passed away before the formalities were completed. However, he did his part. He completed all the steps that he had to do. It's just the formalities part that were still not finalized, but it was not his fault. And then when he passed away, the donee successfully claimed the gift, successfully relied on the law of trust to perfect an invalid gift, an imperfect, an incomplete gift.